May I, Your Lordship? Your Lordship, I beg to mention item number 5 on behalf of Learned Counsel Pritam Thapa, Standing Counsel, Apex Bank.
Yes.
Your Lordship, I have taken consent from the other parties also. Item may be fixed after 2 weeks. Your Lordship.
Okay, up to 4 weeks. Yes.
And Your Lordship, further, Your Lordship, I beg to mention item number 6 to 16, Your Lordship.
Yes.
Your Lordship, I have taken consent from the other parties also.
Yes.
And Your Lordship, this matter may be fixed after 2 weeks, Your Lordship.
Okay, up to 4 weeks. Yes.
Your Lordship, further, I would like to mention item number 18, Your Lordship. 18 and 19, Your Lordship. Oh, sorry, Your Lordship, 18 and 22.
18 and 22.
Yes, Your Lordship.
18 and 22 after 6 weeks. Yes.
My lord, there is interim order.
Sorry, 18, yes, 18 and 22. Interim order pass earlier, shall continue till the next date of listing.
Obliged.
In both the cases,
No, Your Lordship, only on 18.
on
I
18,
think-
okay, 18,
Yes.
in 6 weeks, yes.
Much obliged, Your Lordship.
May I please, my lord?
Yes,
My lord, I beg to mention item number 29 and 30, my lord. I have taken consent from the other side, my lord.
yes. After 4 weeks,
My lord, matter may be taken on 3rd October. my lord.
after 4 weeks.
Otherwise, my lord, after 2 weeks.
I pass the order, mister. If you want to do the case, we'll do the case today. Yes, next,
All right.
May I please, my lord?
yes,
My lord, I would like to mention item number 21.
21,
Yes.
yes.
The council is having health issues, so it may be list after 1 week.
Okay, after 4 weeks,
Yes.
after 4 weeks,
Oh, 4 weeks. All right.
yes,
My lord, I beg to mention item number 25.
25,
Yeah.
yes.
I'm on behalf of the petitioners council, Arsoda. We have to file the rejoinder. We need some more time, my lord.
All right, after 6 weeks,
Much obliged.
Your Lordship, I would like to mention item number 1. The conducting council is out of the station.
item number
1.
1, you can wait, miss. After 4 weeks,
And also I would like to mention item number 4.
item number 4, after 6 weeks,
I'd like to mention item number 19, madam.
item number
19, madam.
19,
Yes, madam. And leading counsel is a Guwahati-based advocate, so.
19 after 6 weeks.
My
Yes,
lord, there is an interim order that will.
interim order. Pass earlier shall continue till the next date of listing.
My lord, I beg to mention item number 17, my lord.
Item number
17.
17
Yes, my lord. The council is out of session.
after 6 weeks.
Bless.
May I plead, Lordship? My lord, I'd like to mention item number 26 and 27 on behalf of these, okay, my lord.
Item number
26 and 27.
26,
Yes, madam.
26
Yeah,
and
but-
27
Yes, madam. I'm appearing on behalf of these, okay, my lord.
Okay,
This for
after-
response number 6. madam.
after 6 weeks. Yes.
Wait, please, your lordship. Lordship, this,
Yes.
through this writ petition.
Oh. Yes.
Lordship, through this writ petition, the petitioners are praying for the issuance of the writ of certiorari for setting aside certain notifications, and as well as praying for the issuance of writ of mandamus, directing the respondent number 3 to recover the wrongful compensation paid to the respondents, private respondents in this matter, Lordship, and pass necessary such orders. Lordship, before I take this honorable court to the certain legal issues here, I'd like to take your Lordship to the very brief facts of this case, Lordship. In fact, Lordship, this is the second round of writ petitions we have been filing before this honorable court. The first writ petition was the first writ petition was numbered as WPC number 425 of 2022. And it was withdrawn with the liberty to file a fresh one due to some defect in the petition. And this honorable court was kind enough to grant permission by order dated 24th November 2022 to withdraw the petition and approach file a fresh one again. And hence this petition, Lordship. Lordship, here the petitioners are the Edu Mishmi tribe of Arunachal Pradesh, who are the native dwellers of the Ilu River belt, generally referred as the Mayapa Iluri, till the right bank of Talu River, Lordship. Lordship, the very brief facts of this case is that, Lordship, in the year 2002, Lordship, the government of India, through the Ministry of Power, handed over the 2,880 megawatt, originally 3,000 megawatt of Dibang multi-purpose project to the NHPC, this is a National Hydroelectric Power Corporation, for executing this said project. And the NHPC, the NHPC, National Hydroelectric Power Corporation, has carried out the survey and proposed a land for acquisition for the said project. And accordingly, Lordship, the government of Arunachal Pradesh, through the Secretary, Land Management Itanagar, write the preliminary notification under Section 4 of Land Acquisition Act 1894, notified that a certain land is going to be acquired, which includes the petitioner's land. And in the preliminary notification, which is in my annexure 4, Lordship, page number 74, preliminary notification in the schedule, which at serial number 9 and 11, that is the land of the petitioner, Lordship. That is the land of the petitioner. After the preliminary notification, the Deputy Commissioner, the respondent number 3, yeah, Lordship, the respondent number 3, write his communication letter dated 28 August 2014, forwarded a report of the proceeding under Section 5 of the Land Acquisition Act and recommended to issue a final notification for the acquisition of the land, Lordship. And accordingly, Lordship, the Commissioner, Land Management Government of Arunachal Pradesh, write his final notification dated 14 December 2014, Lordship. 14 December 2014, final notification was issued under Section 6 of the Land Acquisition Act 1894, Lordship. 1894 for acquiring the total area of 1,628.441 hectares of land, which include the traditional land of the petitioner. And the Deputy Commissioner, who is the respondent number 4, or respondent number 3, via his notice dated 25th January 2016 under Section 9 of the Land Acquisition Act, notifies and invite that any public or the interested person may state their claim against the acquiring land, which has been notified in the final notification dated 14th December 2014, Lordship. And the final hearing for the determination of the land who is entitled for the compensation were fixed in different dates for the different areas, Lordship. And in the petitioner's land was fixed on 18 April of 2016. Lordship, I have enclosed at my annexure 7, Lordship. And thereafter, Your Lordship, thereafter, the final hearing for the determination of my land was fixed on 18 April 2016. Before the hearing could be done, on 16 April 2016, the private respondent here, private respondent number 4 and 5, private respondent 4 and 5, signing as chairman and secretary of a newly formed association known as Adome Elapra Iluli Welfare Society, submitted their names to the Deputy Commissioner, respondent number 4, that we are the project affected families. And the same was not known to the petitioner. The same was not known to the petitioner. And Lordship, thereafter, the circle officer land management Lower Dibang Valley, by his report dated 6 February 2017, submitted a report to the respondent number 3, who's a collector cum deputy commissioner, Lower Dibang Valley, stating that the ownership pertaining to the Iluri downstream and its submergence has been settled, which is the property of the petitioners here, Lordship, which is the property of the petitioner. And looking at the report, I've enclosed at my annexure 9, page number 89, Lordship, 86, Lordship. Looking at the report, it transpires there, Lordship. None of the representative of the petitioners, none of the members of the clan were present during the termination, during the settlement, which transpires their Lordship. This act has been done without the knowledge of the petitioners, just to enrich the private respondent, just to illegally enrich the private respondent. And thereafter, Lordship, the Secretary of Land Management, Government of Financial Affairs, by notification dated 17 March 2017, denotify certain areas, but though the denotify has been done, but the petitioner's land remained the same. It has remained unchanged. Upon coming of the act of the private respondent submitting as project affected families, the respondent, the petitioners here, via their complaint letter dated 30 March 2021, filed a complaint before the collector, respondent number 3, stating that we are the rightful owners. That is my annexure 11, Lordship, page number 100, Lordship. Annexure 11, page number 100, Lordship. Yes. Page number 100. Stating that this is our ancestral property. Hence, we are contemplating to go before the appropriate civil court for the adjudication of a right, title, and ownership of the property. We have made a complaint. And again, I made a complaint. The petitioners made a complaint representation that is 16 April 2021, that is enclosed as annexure 12, page number 102, Lordship. That the map is misleading and wrong, and requesting the deputy commissioner to refer the matter to the competent civil court for the adjudication. And the deputy commissioner here, Lordship, the deputy commissioner, who is a respondent number 3, accordingly disposed of my complaint, via his order dated 9th July 2021, which is enclosed as annexure 13, page number 105, Lordship, has permitted me, has given me a liberty to approach a civil court for the adjudication of the matter. And when he gave me the permission to go before the civil court, I have requested the respondent number 3 to not to disburse the compensation amount as the land is a disputed area. Therefore, I approached before the civil court, civil judge, senior division ruling, Lordship. And my suit is title suit number 7 of 2021. Thereafter, Lordship, the civil court rejected my suit, saying that civil court is bar under section 63 of the Right to Fair Compensation, Transparency, and Inland Acquisition and Rehabilitation and Resettlement Act 2013, Lordship, and rejected my petition. And despite my request to the deputy commissioner, who is the respondent number 3, not to disburse until the disposal of the suit during the pendency of the suit, Lordship, my title suit was dismissed, stating that I'm barred by the Act 2013 under section 63 on 29 March 2022, but the deputy commissioner, via his order dated 1st December 2021, Lordship, 2021, he ordered for disbursing the compensation amount to the private respondent, Lordship. Lordship, here, it is a legal obligation. It is a legal obligation of the collector, who is the respondent number 3, when an application has been filed before him, he has to refer the matter to the competent authority under section 64 of the Right to Fair Compensation Act 2013, Lordship. And the same has not been done. He has given a liberty to approach the civil court, and during the pendency of the civil suit, he has disbursed the compensation amount to the private respondent. Thereafter, Lordship, I approached the district judge Teju, since he is the designated presiding officers under the Act 2013. I have invoked section 64 of the Act 2013. And the learned judge was of the opinion that under the Act, I'm first required to submit an appropriate application before the collector under section 64, and he will refer the same to the competent authority. Therefore, he has disposed of my suit by 31st August 2022, giving me the liberty to approach to the collector with the appropriate application so that he can refer the matter to the competent court. By then, the compensation has been already disbursed by the Lordship. And Lordship, here, the petitioners has sought every possibilities legal remedies here, Lordship. But the same was denied in spite of continuous requests not to disburse the compensation amount, since it is a disputed area, and I've been filing a suit before the appropriate authorities. In spite of referring the same matter to the competent by the deputy commissioner, he referred me to the civil court, and the civil court rejected under section 63 that the civil court is barred from deciding deciding this kind of trial under the Act 2013. Therefore, Lordship, the entire land acquisition proceedings have vitiated the provisions of law in this matter, and as the entire proceedings, land acquisition proceedings known is in law and is illegal. After the proper legal advice, Lordship, the petitioners have approached this honorable court, challenging the entire land acquisition proceedings, Lordship. That is a very brief facts of this case, Lordship. And if I take the Lordship to the certain legal issues in this matter, Lordship, the legal issues, Lordship. Lordship, the Act, Land Acquisition Act 1894 was rescinded with a new Act, Right to Fair Compensation Act 2013, with help from 1st January 2014. 1st January 2014. And Lordship, I have sought an RTI regarding the procedure of land acquisition, and they have provided me my Annexure 3, page number 38, clearly stating, Lordship, page number 38, Lordship. If I take Lordship to serial number 1, may I read, Lordship? There is no award for 3,000 megawatt DMP under section 11 of the Land Acquisition Act 1870, as no acquisition was undertaken under the said act. The land acquisition proceedings for the Dibang multi-purpose project was initiated under the Land Acquisition Act 1894, Lordship. Initiation was done under the Land Acquisition Act 1894, but since it went like this, but since the act had been rescinded with help from 1st January 2014, the award was computed to under section 23 of the Right to Fair Compensation, Transparency in Land Acquisition and Rehabilitation Resettlement Act 2013. The award computed under section 23 of the Act 2013 was approved on 22 February 2019, but was made subjudiced to the so-and-so, and it went the Honorable High Court White Order dated 19 February 2021 in WPC number so directed an out-of-court settlement could arrive at a subsequent date. And in this way, they said that, Lordship, here the act has been rescinded from the 1st January of 2014. 1st January of 2014. If I take Lordship to my petition, paragraph 18, Lordship. No, I'm sorry, paragraph 23, Lordship. Here, Lordship, the first proposal for the land acquisition for the multi-purpose project was made by the NHPC in the year of 2009. 2009, and the preliminary notification for Acquisition Act 1894 was issued by the Secretary, Land Management, Government of Arunachal Pradesh by notification 2003, Lordship. And the final notification here, Section 6, under Section 6 of Land Acquisition Act 1894 was issued 14th December 2014, Lordship. And a notice under Section 9 of Land Acquisition Act 1984 was issued in the year 2016. So these notifications were done after the commencement of the new act. After the commencement of the new act, Lordship. And Lordship, if I take the Lordship to the paragraph number 22 of the writ petition, I have stated the section 24 of the new act 2013. Lordship. It reads like this. May I read, Lordship? Para 22, Lordship. Land acquisition process under Act 1 of 1894 shall be deemed to have lapsed in certain cases. Clause 1, notwithstanding anything contained in this act, in any case of land acquisition proceeding initiated under the Land Acquisition Act 1894, subclause 1, where no award under Section 11 of the said Land Acquisition Act has been made, then all the provisions of this act relating to the determination of the compensation shall apply. Which means that, Lordship, when there is the compensation not paid under Section 11 of the All Act 1894, the determination of the compensation amount, new act shall apply. And here, Lordship, here the respondent have issued the final notification after the commencement of the act. Notify Section 9 of the Land Acquisition Act 1894 after the commencement of the act. And the final approval was done January 22 of 2021, Lordship. Final approval. So legal issue here is that, Lordship, whether the legal issues here, Lordship, that whether the land proceedings, land acquisition proceeding which initiated under the Land Acquisition Act 1894, having been repealed with effect from 1st January 2014 and replaced by the Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation Act 2013, further proceeding under the Act 1894 is barred by the Section 24, Clause 1, Subclause A of the Act 2013. This is one aspect which this Honorable Court has to be dealt with, Lordship. And Lordship, the second aspect. Was the respondent number 3 right in directing the petitioners to approach the civil court instead of bar under Section 63, instead of referring the same under Section 64, the competent authority for the determination of the land compensation entitlement? And one other legal issue, Lord. The presiding officers under the Act, designated presiding officer under the Act, was right in rejecting the application which had invoked Section 63 and approached before the court and directed me to go back to make the appropriate application who has rejected me. Can the Act allows the second time of the application to file an application? So these are the certain legal issues, Lordship, which is here in this petition. Therefore, in this junction, Lordship, I humbly request this Honorable Court to admit this writ petition and issue a notice to the respondent, and upon the hearing, the parties, Lordship, may pass any necessary orders, Lordship.
Yes.
Here, Your Lordship, the petitioner are challenging the land acquisition notification 2016. And Your Lordship, the land compensation has already been paid to the beneficiary. So Your Lordship, notice may be issued in this state, Your Lordship.
Okay. You are Mr.
GUB, Lordship.
G.
GUB, Lordship. GUB.
Ruby.
Yobin, YOBIN, Lordship.
Oh.
Yobin,
Okay. G Obin.
Yobin, Lordship.
G for
Gujusa, Lordship.
Mr. G Obin council petition. And Ms. P Pangu on government. Okay.
1 in 3, Your Lordship.
To accept, issue notice. Pangu for 1 and 3.
Yes, Your Lordship.
Notice to be served through standing council LM. This steps for 4 and 5 by both ways within a week. Notice is returnable 6 weeks.
Your Lordship, extra copy may be
Then
Furnished,
furnish
sir.
extra copy.
organized. Your Lordship.
Right, Your Lordship.
Number 2.
Lordship, on last occasion, Lordship, I was directed to produce documents by which Lordship, the finance department has given the LOC to the power department also. So that the amount can be released to the petitioner also.
Contempt case.
Condemn case. Lordship. I have filed my additional affidavit.
None appears for the petitioner. Add Mr. S. Tapli for the respondent.
Lordship. Okay, it's been taken on Monday or Tuesday, Lordship.
Up to 4 weeks.
Already complied, Lordship.
Complete with.
Eh,
But
Monday.
the person is not here.
Yes.
Uh,
Tuesday, Lordship, Monday or Tuesday.
Yes, then we'll close it. What is the order?
Order, Lordship, at page 12 also. Is
Yeah.
pertaining to pending bills also for constructions of transmission line of 11 kV line from Hoist to Yajale. This is the project name lawsuit,
Hmm.
and it's a page 12 lawsuit. And operating portion is at page 14 lawsuit.
Yes.
I'll read from lawsuit. There are 5 lawsuit. There are
Yes.
5. So and so Learned Council for Finance Department has produced a communication that so and so from the Joint Secretary, the Government of Rajasthan in the Finance Planning and Investment Department, which shows that a LOC authorizations of rupees 30 lakh was issued in the financial year 2019 to 2020 for the work constructions of transmission line of 11 kV line from Hoist to Yajali under so and so. It further shows that the LOC authorizations of the so and so was issued in the financial so and so, but for the financial year 2021-22, no LOC order has been received from the power department. The communications of the finance department makes it understandably clear that the finance department is unable to sanction the required amount is because there is no proposal from the power
Amount has been released.
department.
Amount has been released.
Amount we have given the authorization to the power department lawsuit. The work is pertaining to power department lawsuit. Our duty is only to lawsuit allocate them lawsuit.
Para 8.
Para lawsuit 7 and 8 is important lawsuit. Upon sanction given, the amount concerned be released to the petition within the period of granted finance department. This direction is for the power department lawsuit.
You are representing whom?
I'm for the finance department, and finance department secretary, commissioner and the secretary are the party here also, not the power department. And in contempt lawsuit, they have pleaded cases, they lawsuit, the finance department is not lawsuit allocating the fund lawsuit.
You have granted the sanction.
Lordship. If Lordship take up my Lordship additional affidavit that was filed on 24/8/2020, Lordship.
Additional affidavit. August 28th.
Yes, 24/8/2023, Lordship.
By.
By Dr. Saraj Chauhan, Lordship.
So, yes, which paragraph?
Kindly come to page, Lordship.
2.
In page 2, Lordship, I have given a statement, Lordship. That in terms of the so and so, the planning and investment divisions of the finance planning and investment department so and so allocated the balance amount of rupees 101.02 lakhs in respect of bills pertaining constructions of transmission line of 11 kV line from Hoj to Yajali. And consequently, the budget division has already conveyed approval for grant of LOC authorization by letter dated 3/11/2022, by which the power department has been authorized to utilize the amounts for the said purposes. Lordship. And in support of that, Lordship, annexure 1, that's page 4, Lordship.
All right. None appears for the petitioner. Heard Mr. Estabil for the sole respondent.
Two respondents, both respondents.
Okay, both are finance.
Both are, one is commissioner, other one is
Okay.
secretary.
Respondents 1 and 2. This contempt petition has been filed alleging violation of the order dated 2/12/2021 passed by this court in WPC 112/2021, wherein in paragraph 7 and 8. It has been ordered as under code 7 and 8. So. Respondent number 1, I think.
Lordship, one.
Respondent number 1 has filed an additional affidavit on 28th August 2023, wherein in paragraph 2, it has been stated as under code paragraph 2. In view of driver, I find that the order dated so and so passing WPC so and so has been complied with by the respondents. In view of driver, the contempt petition is discussed.
Both of them.
Well, the prayer made in this read petition has been complied with by the respondent authorities. Thereby, the matter has become infructuous.
Mr. The council for the petitioner submits that the read petition has become infructuous. In view of driver, the petition is dismissed as infructuous.
No.
Grateful.
Yes, will not be rescheduled.
My lord, I have received copy of affidavit in opposition. I want to file rejoinder, my lord.
Okay.
I may be granted 2 weeks' time.
Mr. S. Cohen, learned counsel for the petitioner.
Yes, ma'am.
Petitioner press for is granted 2 weeks' time to file rejoinder to the counter affidavit filed by the state. This
Okay.
will after 2 weeks.
My lord, 3 weeks time maybe.
allowed to file that counter.
Counter affidavit,
Yes.
Mr.
He got it.
T. Gandhi, learned counsel for which is, okay. Standing counsel.
Yes.
The Rajiv Gandhi University Press for is granted 3 weeks time to file counter affidavit. Listed up to 3 weeks.
Interim is there in IA.
Interim.
Yes,
In
in
the
IA.
IA. IA has not been disposed of.
I has already been granted, man.
Huh?
I has already been granted.
IA has already been granted. What granted?
Yeah, it's not.
Interim order process will continue till the next level. It's a common order. Okay.
Right.
No, none appears listed up to 4 weeks. You're there.
Yes.
You have put a respondent, I think,
Yes.
but no one is there for the petitioner. None appears for the petitioner. Had Mr. R.S. Nabam is also there.
Yes, madam, I'm also there.
R.S. Nabam, additional advocate general for which respondent? Respondent number 2 and Mr. B. Picha. Learned here for whom?
One.
Okay, then B. Picha, 1. See. Okay. Respondent 1 is divisional manager, Forest Corporation.
Yes.
And 2 is DFO, Devmali Forest Division. Okay. B Picha for 1 and RS number 2. In view of the non-representative, the respondent number. Okay, now confident, this is up to 4 weeks. Pass the order.